TVASIA Telugu ప్రేక్షకులందరికీ hello and welcome to yet another exciting show of talk show with experts అన్నమాట. నా పేరు నిత్య. I'm your host for today and we have Rahul Reddy garu. Thank you for so much for being here, Rahul garu. As you all know, Rahul Reddy garu is a very, very prominent immigration lawyer, and his company in Houston, Reddy and Newman PC and Yoka company, tirelessly fighting for so many immigrants, day and night, and he's also here with us today and every week to answer all of your questions, Anumata. So please fire away. Rahul garu, I know we have a lot of questions lined up today, but in a strange twist of events, we're going to be discussing one main topic, that is the government has dropped this policy that's prohibiting the fall online classes for these F-1 students, Anumata. Also, the second one is about the consulates and them beginning to reopen. Let's start with this first thing. What's happening with this? Why did the government finally agree to drop this policy? And does it mean that the students are free to attend online classes while living in the US? Given the situation that's going on, can you tell us about it?
Sure. Thanks for inviting us, Anita Garu. This government has not done it by itself. It was forced to do it. మీకు తెలిసిన ఉంటుంది హార్వర్డ్ యూనివర్సిటీ అండ్ Massachusetts Institute of Technology. These are the most prestigious institutions in the entire world.
Right.
And they believed in that this government is doing wrong things in telling the people to attend the classes when the whole situation is so bad, while the CDC is telling not to conduct any of these such classes live, while the government is telling a different story. So they went to the court, and before the court could give any judgment or injunction, the government dropped its idea and then said that those people who are already have a student visa and are in USA, they can attend the live, they don't have to attend the live classes, and they can have a complete semester to be online classes, and that will be legal. However, though, the administration is a little bit more strict on the people who are going to obtain the visas for those people who are coming in this fall semester. They want those students to attend the live classes. If they don't have a live classes, they may not give the visas at this point of time. But it's a little bit, government has backed off on its stance, which is a good news for it, and it's the court system that has brought up into it. Nitya Garu, you asked another question about the consulates getting reopened. Yes, consulates are getting reopened. They started issuing visas right now. They're giving more preference to the F-1 student visas right now. The reason why they're giving preference to the F-1 student visas is that their universities have to start in August. And if they were to come into the United States, they need to come in very early. I mean, they need to have those things. There are a lot of backlogs. Approximately around 500 to 600,000 students will be given visas every year, student visas, and they're backlogged. And the consulates are not fully functional at this point of time. They're only giving some visas and not giving other visas. Miku manam last week already presentation up to already H1, H4, tarvata J1 visas వాళ్ళకి already ban ఉంది. కానీ ఇప్పుడు B1, B2 గానీ ఇప్పుడు then F1 గానీ they can apply for the visas. Andro, they're going to give preference to the student visas for appointment. When you go and fill the DS-160, if it's a student visa, they'll get a priority over B2 visa.
Oh, great. That's fantastic news, Kada, actually.
Yeah.
At least, it's a major relief. And that suspense was killing people, whether, they go back home or, they can stay here. And with so many uncertainties all over the world, I think this has come as a relief of a news.
Mm-hmm. Right.
So that's great, Rahul garu. I think we already have a couple of callers waiting for us. Let's just quickly take their calls and then we'll come back
Sure.
for discussion.
Sure.
Let's go on to our first caller. Hello.
Hi, Rahul. Hi. This is Umesh here. Are you able to hear me?
Yeah, hi.
I can hear you, Umesh. Sorry.
Yeah, thank you. Thanks for hosting this call. I do have a question. This is not regarding the student visa or something. This is regarding something like the I-140. Can I ask that question now?
Go ahead. Absolutely, go ahead.
Yeah. So my I-140 is approved and it's almost 180 days now, and I'm changing the employer. So the new employer can file the H4 EAD with the existing I-140, or they need to file a new I-140 for that?
And you said the I-140 has been approved for more than 6 months, right? Since the I-140 has been approved for more than 6 months, when you go and join a new employer, they can use this existing I-140 to apply for your wife's H4 EAD. They don't need to get another I-140 to get your wife the EAD.
Okay. And I do have one more question on the same thing. My previous employer is asking for the liquidated damages for the H1 extension and other sponsorship. But as per the legal this thing, right, they can't ask for these fees. But in the agreement, whenever I was being recruited, they had mentioned that if anything happens and I need to move out of the company, then I need to pay something as a liquidated damages. This is not for the H1 transfer or something. This is for some casework they have did on my case. So what should I do in this situation? Like they're asking around...
asking around what?
$5,000 for that. Because they recently filed my extension. Yeah.
They cannot request any money for the extensions of filing the H-1B. They can't request for the legal fees or filing for the extensions. It'll be very hard to enforce, but I will limit myself since I'm just an immigration lawyer, not a contracts lawyer. This is more related to contracts. But as far as the immigration is concerned, though, if you leave and join the other company, you're not in violation of any immigration law. If they will try to enforce, there is something called W4. When you go to the Department of Labor, Google it, Department of Labor, W4. You can file a complaint. They will be very strict and they will go to action. So that's what I would suggest to you at this point of time.
Yeah, thanks, Rahul. They have mentioned in the contract saying that this is not a legal fees for the H1, but this is something on the contract only.
I would still recommend to contact the DOL with a W4 form, and they may get scared off on that thing. Okay.
Okay. Thanks, Rahul.
Thank you very much, Umesh.
Thank you, Umesh. Rahul, there was some call with people demanding money now. But before we get back to extortion, let's take up a couple more callers. Hello.
Hello.
Hi.
Hello, can you? Hi, my name is Pawan. Hello, Rahul.
Yes, go ahead, Pawan. How can I help you?
Yeah, I mean like this. So this year, like my H1B got approved, and then but I enrolled into CPT as well. I mean like without. I didn't make use of the gap, and then I enrolled for CPT, and also my H1B got approved. But like my question is like since starting from October 1st, I will be in H1B status, right? So after October 1st, so if I drop out from that CPT college, so is there any problem? And also if I go for stamping, say for example, in 2021 John, if I go for stamping in India, so will there be any problem? I mean, like since I dropped out, I mean, like, from the CPT.
As far as dropping out of the school, you will be on H1B starting from October 1st. So there is absolutely no need for you to continue in the school if you don't want to. As far as you dropping out of school after October 1st, that by itself should not be any problem whatsoever at all for you to get the stamping. You are in H1B. You are under no obligation to go to school.
Okay. I mean, like I completely get that. Like when I was speaking with different people, like they were saying, like if you, if you go for stamping, they might raise a question saying like, why did you enroll for CPT? I mean, just to maintain the status.
That's a different question. You said dropping out of the school from October 1st is a different question from Day 1 CPT. Day 1 CPTs are always dangerous. We don't recommend people to join it. It's very dangerous to join a Day 1 CPTs. We don't consider these universities as legitimate universities. Now, what I'm telling my opinion right now is my opinion only, not the TVASIA Telugu opinion, but this is my personal opinion, and any liability should come to me, not to TVASIA. The universities like Cumberland, Campusville, or the Harrisburg universities, we do not like these universities at all. We don't think so they're following the regulations. So yes, So if you join any of the university, you may be questioned very much at the consulate. I would strongly recommend before you go there, you should consult a lawyer before you go to the consulate.
Okay. So like you're suggesting to continue doing the CPT, day 1 CPT until you go for stamping and also consult a lawyer.
No, as far as you continuing after October 1st, no need to continue after October 1st under any circumstances. You don't need to.
Okay. I get that. Yeah. Yeah, that's all I wanted to know. Thank you.
Thank you.
All right. Rahul, I think we have a couple more callers, so let's just take the calls quickly.
Sure.
Hi, hello.
Hello.
Hi.
Hey, hi Rahul, this is Vic. So I had a question. Basically, I was on H-1B and then I lost my job. So I went back to Mexico to change my status from H-1B to H-4. Okay. Now, what happened was on my passport, the I-94 says H-4, that stamp is there. But when I checked online, it is showing as still H-1B. So I'm kind of worried right now whether, what should I do now?
So on the passport stamping, you have the H-4, but on the online, it still says H-1B. Did you check if the I-94 number that you received online, is it the same old I-94 number when you entered into United States on H-4 or some other visa and converted into, or is it changed?
Honestly, I need to check back again, but I can verify that.
You can verify it and come back to our to the next week, because I need to know that. Is it changed? Because if it's not changed, so practically maybe we are not looking at the proper I-94 number. So you can either way contact the CBP through email, request them and give them the evidence. They would be able to correct that information. There is also called deferred inspection. You can make an appointment with the local office and go visit them and explain to them, look, I got the H-4 stamping. I'm supposed to get the I-94, and they will correct that one in the deferred inspection.
Okay, perfect. Hey, and just one more question. So I have I-140 file right now, So so if a new employer wants to get my or transfer my H-1, will it be just a transfer of H-1, or do you need to file a new H-1, or how does it work?
I'm assuming that you completed your 6 years of H-1B, is that right?
Yes, that's correct. And then what happened with my previous employer?
You filed an I-140, but your I-140 is never approved right now. So you technically are not eligible for the more than 6 years of H-1B, because you said I-140 has been filed, but it's not approved yet.
No, sorry. Let me correct that. My I-140 was approved in 2014. Okay, so I have been on extension. So that's not the thing.
Oh,
the only question I had was, with my past employer, right? Before I got laid off, they filed for my new H-1, and that's valid till 2023. Okay, and I also have a H-4 EAD stamp on my passport, which is ending next month. So my question is,
not H-4 EAD, only H-4.
Okay, only H-4. Yeah. Okay.
Yeah. Okay.
So my question is, if I have a company which is kind of almost ready to file for my H-1, so will it be a H-1 transfer, or will it be a new H-1 for them?
It will be considered as change of status from H-4 to H-1B, but you will not be subject to cap. You don't have to go through the lottery. It will be change of status from H-4 to H-1, but not subject to the lottery.
Okay, perfect. And hey, so in case, suppose because my H-4 is expiring next month, and my wife has filed for her H-1, and suppose if this company is not sponsoring my H-1, assuming that I'm still on H-4, okay? And the issue with her is she works in IT, and the company is filing for part-time H-1B, And so with the part-time H-1B, does the H-4 extension or H-4 EAD extension has any problem, or these are two different departments, so it doesn't matter what happens on the H-1 side?
theoretically, it is not a problem to have a part-time H-1B and H-4 and EAD to be adjudicated, unless the threshold of the income falls below the poverty line. Typically, for the people of 2 or 3 people, the poverty line is about $35,000 per year. If it falls above, though, okay, there's actually poverty guidelines plus 25% extra for immigrants. So if she falls above that, I don't see any problem in getting the H-4 and EAD.
Okay, perfect. Thank you so much. Appreciate that.
Thanks a lot. Thank you. Thank you.
All right, Vic, thank you for calling. Rahul, we have a couple more callers waiting. Let's just take their call as well. Hello? Hello? Hello?
Hello. Can you hear me?
Yes.
Yeah. So this is Srikanth. Currently, my status is H-1B. So recently, in the March, I moved my employer to a new employer. There, when they filed my petition, so I got an RFP for specialty occupation.
Mm-hmm.
So here, the case is my bachelor's degree is non-computers, okay?
Mm-hmm.
And I have an experience of 10 years in the IT.
Mm-hmm. Mm-hmm.
So I'm not sure like how I should approach with my submission of the RFP.
Okay, one thing is that you need to get a specialty, the education evaluation again, even though you have received an education evaluation before, though. What degree do you have? You said it's non-IT. What degree do you have?
So basically, I have my Bachelor's of Commerce degree, but post to that, I have a PG diploma, which is also like a regular university degree of 3 semesters, which is in my computer science management.
Got it. So it's, I have to tell you that if you, when is your I-94 expiring?
My I-94 is expiring 2021 June.
Okay, is this a transfer of H-1B or amendment plus extension?
It's a transfer H-1B.
Okay. You have to take it very seriously. We are seeing a lot of denials for the specialty occupation. Now, since the USCIS has rescinded its memo that they issued in 2010 and also in 2018 on the employer-employee relationship, the denials of the specialty occupation definitely have not gone down. It's only the employer-employee relationship denials have significantly gone down. If you have what you said, PG diploma and BCom, it is a very tough game for you. I want you to get the education evaluation again. I also want a professor to evaluate whether the position requires a specific degree or not. And that's, you have to pay a professor. This costs a lot more money. And the professor, I strongly recommend, should to speak with you and employer before he gives opinion. We're noticing that if the expert evaluations are getting done when the professors are not speaking with the employer and employee, USCIS is denying it. So it's better that the professor gives an evaluation after he speaks with you and your employer. These are the best things in your strategy right now, but I want you to take all these things very seriously, what I spoke, and do it before you respond to the RFP so that the lawyer will have good weapons to fight for your H-1B approval.
Okay. So here, like, as I said, I have even the PG diploma regular.
You told me that. You told me BCom. You told me BCom. You told me 10 years experience. You told me 3 semesters of the PG diploma. I'm aware of it. But still, I would
okay.
say that, you know, there's a high risk case. Okay?
Okay. So the last question, in case, like if something goes wrong and if my anything like it get denied, then what would be my status? As still my I-94 is valid till next year, July. So
you told me that.
Still my employer could able to. So still my employer could able to like file a new petition with the same client and the same employer, or what would be the next status?
He could do it under the 60-day rule. We have tried sometimes, and some of the officers agreed with us saying that the 60-day rule is applicable because you're I-94, but sometimes the officers did not agree. If by any chance your employer is going to do it the second time, I definitely want him to do it premium processing. I would also ideally tell that if you are going to refile the H-1B, I would rather want you to file the application with a company, different company than the existing company, if that's possible. Because when an officer is looking at your application, there was already a denial of the application. So now, let's say I'm the officer, the other officer denied the application, now I have to approve. There is an extra burden on me to deny his application. So that's the reason why if you go to a different employer, you'll have a better chance. In situations where you are in right now, we normally recommend people don't join the second company until you get the H-1B approval. But you already joined the company, so you already took the step, you already risked it. But right now, you don't have an option coming back to the old company. If that option is there, I will tell you to come back to the old company. You will have to take a risk right now. Thank you very much for coming. Sure.
Yep. Thanks, Rahul. Thank you.
I think so. You're muted, Nitya. Nitya, I'm having some technical issues. I can't hear you. Nitya, I'm having some technical issues. I can't hear you.
Yes, 1 minute.
Okay. No, you're good.
Okay,
you're good,
awesome. No, there was a technical glitch and I got muted out. Sorry about that. But I think we have a few more callers, Rahul Garu. So let's go ahead and quickly take the callers as well. Hello? 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 Hello?
Yes.
Hello, can you hear me?
Yeah, we can hear you now. Hello?
Yeah, hello, sir. I have a couple of questions regarding my H-1B amendment as well as H-1B transfer. My H-1B was approved in last July, and my employer then filed a couple of amendments, and they are going to file the third amendment like in upcoming week. All the previous application was approved, and right now I have a new employer, and they also want to file H-1B transfer in like upcoming week. So my question is, will those two applications like affect each other or not? The first question is.
Let me ask, when is your I-94 with your current employer expiring?
That expiring in 2022, July 2022.
Your amendment or your filing with two other employers while the amendment is pending will not cause any problem whatsoever at all for your status. All three applications will be independently adjudicated. If one gets denied, that doesn't mean that the other thing will get denied.
Okay. And once the other question is, for the second amendment, I got approved and then they sent me like intent to revoke notice. My employer didn't reply that notice because we have 90 days to reply.
This is for the amendment or is it for the underlying first H-1B application that you received a notice of intent to revoke?
This is for the second amendment. They approved first and they sent like intent to revoke notice because they did the client visit. Then my employer also filed the third amendment, and it was also approved.
You can always respond to the intent to revoke, mentioning that, look, at the time you had a site visit, I have actually joined the client C, and a duly filed LCA and the H-1B amendment was being filed. You show them the evidence, and you withdraw the amendment if you want to. You can withdraw the amendment.
Okay. but that intent to revoke notice affect my H1 transfer application on either way?
I'm not expecting that to cause any problem. If the first H1B that for which you have been counted for the lottery got into trouble, then you would be in trouble. But right now, I don't see that it's going to cause any problem whatsoever at all.
Okay, and one more thing, sir. So right now, my current employer, applying another amendment in next week. Will their amendment affect because of this previous intent to revoke notice or not?
No, because you've rightfully done everything correctly. If you would have not worked for the other client C, and if your company has not filed an amendment for client C while you're working for client C, that would have caused amendment. But right now, your employer followed every rule that exists, and he did it rightfully and a perfect timing. So I'm not expecting that to cause any problem for your current amendment, which they're going to file within a week's time.
Okay, and the last question. Is it compulsory to reply for that intent to revoke notice?
Yes, it is compulsory to respond to that intent to revoke. Okay?
Yeah, because my plan is when my transfer will get approved, I will move to another new company.
No, sir. You need to respond to that intent to revoke. If you don't, you're practically accepting that you were not there, you didn't follow the law. So I would respond to the intent to revoke. Thank you very much for
but that will. Yeah, but that will cancel, sir, my H1B amendment only, right? Not my main petition. If I will not.
You are absolutely right. No, if you don't respond to it, there will be a record on you that there is an intent to revoke, and they have revoked it because you didn't follow the law, which is not good for you. I don't see any reason why you are not going to respond to that.
Yeah, but my employer suppose they will not respond because I will join another company. So they directly withdraw my petition. So I'm thinking about that.
But if he's withdrawing, they're still responding to the RFP, notice of intent to revoke.
Oh, okay. So they will mention that reason.
It'll be in their bad record too, saying that they did something wrong when they did not. So I don't see why the company will have a bad record on it when they're completely clean company. Okay? Okay. Thank you then.
Thank you.
Yeah, thank you.
All right, Rahul Garu, let's move on to our next caller.
Sure.
Hello?
Hello, this is Monali.
Hi, Monali.
Hello. Good afternoon. Yeah, this is Monali. Can I go ahead with my question?
Absolutely, please.
Yeah, so hi Rahul, this is Monali. Good afternoon. My I-140 is approved and my H-1B is expiring in September 2020. So I want to ask, is it too late for me to switch to F-1 visa if I want to?
Yes, it's too late. One reason is that if you're going to apply for the F-1 visa, you have to maintain your status until the F-1 is approved. And you know that the time it's taking to get the F-1 approval is anywhere between 8 to 18 months. So that means that after September of 2020, you will be out of status unless you move to either B2 or you're eligible for H4 or you extend the H1B. So that's very risky to move into F1 status though. Are you have a chance of moving to H4?
No, I'm on H1. My husband is on H4EAD. And the another question is, Rahul, my employer is in process of filing my H1B in extension in premium. And
that's very nice. That's a very good idea. That's a very good idea to file in premium processing to get the result before your I-94 comes in. If by any chance your H1B gets denied, the company gets a chance to file the second extension, even though the first has been denied, or you can move to a different company. So your company seems to be doing a rightful thing, but filing an extension in premium processing.
Okay. And if I get the RFE during that period of time when my H1B is expiring, so how it will work?
Well, you can respond to the RFE, and even if you get the denial, you can file the extension if before your I-94 expires. The other technique that I use in some times where we don't have enough time to respond to the RFE is while you're responding to the RFE, you can even file one more extension to see if this gets denied. You rely on the other extension that you filed. So you can have a backup plan if you do all these things well ahead of time.
Okay, thank you so much. Here is my husband. He wants to ask a question.
Sure. Just one question, right? So now, I guess since her is expiring in September, mine is also expiring in September, right? And we both are trying to get someone to sponsor this one. Okay. So my question is, I have already done my master's here. So, in case if I want to switch. Okay, you said that the only option right now, looking at the time frame to get to change status from H4 or H1 to F1 is going on B2 visa, right? So if any of us go to B2 visa, do both of us have to go to B2 visa, or just one person can go to B2, or how does it?
No, one person can go to B2 visa. I suggested your wife to go to B2 visa. I wouldn't suggest you to go to B2 visa. In your case, you can continue to be an H4 status, and you can extend the H4 and then file a F1 if you want to. In your wife's case, of course, she can't move to the H4. I already checked it, right? That's the reason I may have told you, or I suggested you that B2 might be an option for her. But in your case, though, if your wife is going to extend the H1B, I don't want you to move to B2. I want you to move to only H4, extend the H4 and file the F1 visa if you want to.
Okay. Yeah. Okay, yeah. No, the reason I ask you that is because in case I'm just trying to go with the plan B, right? Suppose if something happens and her H1B is not approved till 6th September or something like that, right?
That's a reason the plan B I suggested is much better for her to have the extension result come by September 16th and filing a second H1B. That would be better plan B than your plan B, though.
Okay. Thank you so much. I appreciate that. Thanks a lot.
Thank you.
Bye-bye.
Thank you very much. Thank you very much.
All right. Rahul, let's just quickly take one more call before I have one topic that I want to discuss with you for sure.
Sure.
Let's go ahead. Hello?
Hello.
Hi.
Hello.
Hello. Hi. We can hear you, sir.
Are you able to hear?
Yeah.
Are you able to hear?
We are.
Yeah. Hi. Hello.
Yes. Hi. May I know who's calling?
Yeah. Calling Srinivasarao.
Hi. Please go ahead with your question.
Yeah.
You may want to keep the TV, YouTube TV off, sir.
Yeah. I think the only one question is we applied from H4 to F1.
Can you make the TV or
are you able to hear?
Can you make your video off, the TV off, please, because we're able to have a lot of disturbance.
Are you able to hear, sir?
We're getting a lot of disturbance. Can you put the TV off, please, or the video off? No, it's better. Are you there?
Hello? Oh, I think he
well, we have to wait for him to come.
I think he got a little confused, but Srinivas Rao, please call us back. Keep your TV on mute because there's a lot of feedback that's coming on the loop. So please call us back and we'd be happy to help you. We have two more callers, but really quick, Rahul Garu, there's a lot of talk circulating in the Telugu community law that the dates for the adjustment of status is going to be current, or that they will allow all I-140 approved people to file AOS. Now that's big news. So Dan gurinchi kuch cheptara, please.
I wouldn't say there is a good possibility. I wouldn't say that the rumors have no basis whatsoever at all. Okay. There are two different things, Nitya Garu, that I want all the audiences to be attentive on. One thing is that President Trump is giving mixed signals for the administration on the immigration right now. On the one hand, he says he's going to ban the immigration. Another hand, he's saying that I'm going to have a executive order signed executive order, and then he says, then he switched that from executive order to saying that we're going to pass a legislation. So it's very confusing, saying that it's going to be a merit-based system. That's the Republican way, is what he's telling. Right. So that has some thought process in there to have, if an I-140 has been approved, there is a possibility that he may allow to file the adjustment of status. Now, this administration has the authority to give the to allow the people to file the adjustment of status even if the priority date is not correct. This was been expressed before in the Obama administration. We expected him to do the I-140 when the I-140 is approved, to allow people to file the adjustment of status. But when reality came in, he didn't do it. Trump administration is giving a signal that he may do it. He's giving a signal, but I don't know if he's going to do it, because his Republican base does not support, his particular base, election base, does not support this idea. But I don't know if he's going to do it. On the other topic, which is also related to immigration, he's telling that I'm going to pass an executive order allowing the DACA recipient, that is approximately around 900,000 people, to get the citizenship. So he's giving mixed signals. Previously, he was telling that he wants to throw all of them out of this country. Right. And now he's telling that he may give it. So it may be an election strategy for him to either provide any benefits to the DACA and maybe for I-140 benefits. So we need to look into, this is election year. We are just at the almost in the middle of July. We have about 3 months or 4 months left to complete to the entire election process. We may get some surprises from Trump administration. Just because he's a Republican Party guy and is not that favorable to immigration, you never know. At the end of the moment, their heart may do differently, and they may do some different strategies. Right. I've seen that the most conservative president that I know about is Ronald Reagan. But he gave all the unlawful people at that point of time, whoever has been in the country before 1983, he just gave them everybody green card. Right. I mean, that's how Ronald Reagan was. So I don't know if this guy might do some surprise. That's one reason why I think so that the rumor has some merits. The second thing is that there are family preference immigration categories. That is for brothers and sisters of U.S. citizens, the green card holder spouses and children, adult children also, but not the married children. And also for those people, U.S. citizens, adult children, more than 21 years, even married children. The Trump administration put a bar from all March to all the way to October of 2020. Now, I would say that it's until December 31st of 2020, but actually the year ends on September 30th of 2020. So from March onwards, all the way to September, you're speaking March, April, May, June, July, August, September. So almost like 7 months, he put a bar. So the amount of green cards that were allocated to the family immigration, if they don't use it in that particular year, they have to give it to the employment-based green cards. So that may be approximately 60,000 plus green cards coming into the employment-based green cards to add to the 140,000 green cards.
Nice. Okay.
Not only that, the USCIS have changed its policy with regards to the adjustment of status interviews. And they said that those people who file the adjustment of status, they will not get the green card until they were being interviewed by the USCIS officer if they filed the application in March or after March of 2017. Okay. Now, from March of 2020, the administration has closed because of the COVID situation. They have recently opened it. They're not even conducting full-scale interviews. So there'll be a lot of leftover green cards. And the Department of State is very upset. There are people waiting for the green card and you don't want to give the green card. How can we answer to the Congress? Because the Department of State have to answer to the Congress. There are 600,000 people waiting for the green card. And now you're saying that it's backlogged and you're not giving the green card. They'll be very offensive. The State Department can all of a sudden, I'm not telling that they will, but they can do, all of a sudden they can say all the priority dates are correct. Right. You may ask Nitya, did it ever happen? Yes, it happened. In 2007, of July 2007, the State Department got so mad because the USCIS did not vote on it. On one single day, they said the priority date is correct for everybody. Mm-hmm. And everybody filed the adjustment of status. Yeah. Now, this entire thing is a perfect storm for the State Department to make the priority date current. So there is a possibility on that too. So there are two fronts. There is a possibility of what the rumor is. But we'll have to see when the things materialize, how the State Department act or the administration is going to act on it.
Okay, yeah, fair enough. But yeah, I think if it does happen, then it's great. And,
it's going to be good for all Indians. For sure, 60,000 Indians are going to get benefited with this, but there may be more. We'll have to see.
Got it. Okay. Rahul, we have a bunch of callers waiting, so we'll quickly take their calls as well. Hello?
Hello. Hi.
Hello. Is this Srinivas?
Yeah, are you able to hear?
Yes.
Yes.
Okay.
Yes.
Come back. Yes, we are able to hear you. Thank you.
Yeah, sorry. Yeah, actually, I applied for H4 to F1 extension for my daughter. She's because of aging out. Earlier, I spoke with Rahul on this scenario. Mm-hmm. I have one quick question. When we wrote the statement of letter, we mentioned that one letter after graduation, she will be back to India because we wrote the statement like that. So, but the graduation means by any chance will they consider after the undergraduation, the people will treat as a graduation, whether they will treat that is a graduation or our intention is after masters technically. Is there any confusion will come into picture? Later?
At this point of time, we are not seeing much denials whatsoever at all from H4 to F1 visas though. No matter how they consider it, whether the graduation is the master's degree, graduation is bachelor's degree, even little kids who goes to school from the kindergarten, they get graduated from their school too. From their first grade to second grade, they get graduation too. So it doesn't matter how they take it. I'm not expecting that they will keep any objections or deny the F1 visa. When the F1 visa, change of status, has been granted though, your daughter is not going to get it for a particular date, even though you may have given a statement on when you file for the F1, your daughter might have given a statement. Yes. They will give called duration of status. So it doesn't have any limitation though. They can't give, okay, she's going to graduate in June of 2022. So we are going to only give until June of 2022. There is no provision for that. They have to give until duration of status. So she'll be fine. I'm not expecting any problem. But I have one question to you though. When is she becoming 21?
She is turning 21 in the November, actually November 22nd.
November 22nd of which year?
2020. We
2020.
Applied for change after, we applied in H4 to F1 in the March period.
I would strongly recommend though, if by any chance your daughter does not get the F1 approved by October, that you should contact a lawyer. The reason is that she has to maintain the H4 status until she gets the F1. The problem with her is that when November 22nd comes in, she turns 21, she's automatically kicked out of the H4 status and they won't grant the F1. They will deny the F1 unless you file something called interim B2 application. Okay?
Okay, sure.
Be careful on that. Be careful about that because otherwise you will be in trouble. Thank you. Next caller.
What is the best time to file the bridge application? Is it 30 days before?
That would be more ideal. That will be more ideal, sir.
Okay, good. Yeah, thank you. Thanks, Rahul. And also, final one more quick question. Yeah, when recently she got the H4 approval on the January, at that time already biometrics are completed. Is there any chance they can reuse that biometrics for the F1?
They can reuse the biometrics, what she has done for the H4 for the F1. They can. There is a possibility for it. But you never know, this administration. They may or may not. They have the authority to use it.
Okay. Yeah, really appreciate Rahul. Yeah, thank you.
very much.
Thanks for
Thank you for
clarification. Yeah, appreciate.
Thank you, Srinivas Garu. Rahul Garu, we have one question from one of our YouTube viewers before we go on to the next call. Let's just quickly go through his question. This is from Manoj Chinkala. He says, hi, I have a question on extension of visitors visa beyond 365 days and related legal implications. What are the chances of getting approval for a second extension on the basis of old age and COVID?
Wow, that's a very complex question though. Normally, we do not recommend people to stay all the 6 months period and extend it. So if you have extended it after the COVID situation, it makes sense. But if you have extended it before the COVID situation, that definitely was not a good idea to do it. But under the current circumstances, though, you don't have much option. You don't want to risk your parents to go in this COVID situation. You can apply for the B2 extension, but there may be it may complicate the issue when they are going to try to come back into this country at a later date. I would surely consult a lawyer before you, under the current circumstances, you can file for the second extension, absolutely. Because of the COVID situation, you don't want to send them. But if you have plans to bring them back into United States at that point of time, I would strongly recommend to consult a lawyer. There are two situations, because if the B2 is denied, that may cause a problem though. The second option is that if when people have stayed in the country for more than 1 year, when they are going to try to come back into United States, they are going to look into, is this people staying in USA visiting India, or they're actually staying in India and visiting into this country. So those questions and answers, what they articulate to the Customs and Border Protection Unit is very important. I would have them speak with a lawyer to make sure that they're doing it properly, or postpone the trip. Otherwise, they'll be in trouble.
Okay, fair enough. All right, Manoj Garu, if you're watching the show, then there you have your answer there. We'll just go on to our next caller right now.
Yeah, hi Rahul. My name is Sainath.
I'm sorry?
Hi Rahul, my name is Sainath.
Sainath, go ahead please.
Yes. Rahul, thanks for the opportunity. And so my friend, he's in India right now, so I'm asking question on behalf of her. So she applied for H1 visa, and she paid she paid for the visa by submitting DS-160 form. But however, she wants to change some information on DS-160 because of some typo on the date. What is the process? Can she has to cancel the existing DS-160 form?
She doesn't have to cancel. She can send an email to the consulate telling what exactly she wants to change it. And she should take that information when she goes for the interview. I have seen when people have sent an email, the consulate officer responded and allowed them to change the clerical corrections, what they are supposed to do, what they wanted to do. In some cases, they did not allow it, but when they went to the consulate rightly identified and mentioned it when the interview happened. You wanted to correct this one, yes. Can you sign this thing? They made them sign the correction. They manually corrected and have them sign. Like for example, let's say if their address is a different address, that they manually have it corrected. So as long as you send the email to them and you take it with you at the time when you go for the interview, you are safe. You don't have to cancel and make a new appointment. But if there is something, a grave change where complete misinformation has been provided though, I may want to cancel and make another appointment. Otherwise, it's just a technical thing. Date of birth is wrong. Address has been sent wrong. And any technical information has been given wrong. You don't have to cancel the appointment, make a new appointment, sir.
Thanks, Rahul. I have one more question. So you mentioned a couple of minutes back, actually, like there is a possibility that the green cards can become current. So I have my green card process started with my previous employer, and I moved to a different employer right now. And the current employer, they have a policy to start like whenever they feel it's the right
if
time.
you don't have an I-140 approval with your current employer, though, if the priority date becomes current, you will not be able to take advantage of the situation. Now, what I said is just a possibility, though. I mean, I did not say that, it is going to happen. I hope it happens, but it's just a possibility. Yes, if the dates become current, though, yes, you will not be in a good situation at that point of time. Even if they allow you to file the adjustment of status with the I-140, even if the priority dates are not current, you will not be able to do it because you're not working for the same company that filed an I-140 for you. And this company has to hurry up and file the labor and I-140. If they don't file it, there's not much you can do right now.
Is there any minimum requirement that I have to file, or like any required documents, or it has to be finished completely and get?
I-140 has to be approved or at least been filed, depending on how the things are going to be for you to file the adjustment of status. If the labor certification has not been done, you know that you can't file an I-140. And labor certification by itself will take approximately 1 year to get the entire process done.
Can I, one last question, can I talk to my previous employer and see if they can provide some letter or some kind of documentation?
It's letter is not enough. One, I don't know if the I-140 has been withdrawn. If it's been withdrawn, they may not be able to help you. If it's not been withdrawn, under limited circumstances, if your intention is to go back and join them, at the same time the company wants to take you, there are some risks involved in it, but you can look into the possibility of going to the old employer and file the adjustment of status.
Got you, sir. Thank you so much.
Thank you for joining our show.
Thank you. Now, guys, we have another caller. Let's go there quickly. Hello? Hello?
Hello, can you hear me?
Yes, we can. May I know your name, please?
Hi. Yes. Hi. I have a question regarding parents visitors visa. I know I just heard about the previous conversation from the previous comment from the chat, but my parents have extended their visitors visa one time. They came here in October, were supposed to leave in April, but flights got shut down, and now they are in their first extension time period. Being a citizens, we can file them for green card, but I don't know with the COVID, how is the green card filing for the parents will be working, and what would be your advice whether to apply for a second extension because they are elderly?
Let me ask you this simple question though. Do they intend to stay here on the long-term basis, or they just want to extend the stay?
They're worried about going back, or I am worried about sending them in the COVID situation, and they have an intent of staying long term. I mean,
okay, if they have intention of staying the long term though, you can file the green card application. Once you file the green card application, you don't have to file a B2 extension. You're fine. They can be an adjustment of status. The adjustment of status for the immediate relatives is going on fine. There is no executive order. There is no law. Nothing has changed on that. You told me that you are a U.S. citizen. You can file an I-130 and 485 application and the entire package for you and for your mom and your dad. And once you file that application, they can stay here for good. Are there any hiccups on filing the green card applications? Sometimes the USCIS officers are very, they want to say, get me the birth certificate of your mom, get me a birth certificate of dad, show the relationship between you and them. I have a very good weapon that I sometimes use it, and people get flattened out when I use that weapon. And I have done it because the officers are very nasty, and then I want to get over with them once and for all, and I use that weapon. I call that as a DNA test. That works out very good, and nobody can deny that they are your parents. So it's more or less a simple process. There is a lot of paperwork, but do I see any denials? Do I see any risks involved in it? As long as you're willing to use the weapon that I told you, absolutely there will not be any problem.
Got it. And because they're still within, we did not get any extension approval or anything.
That's fine.
But we just filed, we got the receipt.
You can still file the green card with the receipt notice of the B2 extension that you filed. If they intend to stay here, just file a green card application, get it over with.
Got it. And that's probably the safest bet rather than applying for second extension, right?
Right. Remember that when they want to go out and when they want to come in, there may be a problem for it. You will avoid all that problem and get the green card once for all.
And it's safer for them to stay here and apply rather than going back. I mean,
absolutely. For them to apply while they're in India or here, it's much safer when they're here.
Perfect. Thank you so much. Greatly appreciate your help.
Thank you. So Rahul Garu, your weapon of a DNA test was like amazing. I've never heard of that.
I got one 485 denial. Because I got my 485 denial, I didn't have enough. And then I had to file I-130 and 485 again. And that's the reason why I learned the lesson of using, this is a long time ago, 15 years ago though. I started using that and it's working out properly.
Got it. Rahul Garu, we seem to have lost your video.
Yeah, you'll get it. Give us 1 second, you'll get it. There's some technical things there. Yeah, I'm back.
Back here. Yeah, okay. Great. I think we have one more caller. So we'll just quickly take that call as well. Hello?
Yeah, hi. My name is Sandeep. I have a question. Can I go ahead, please?
Please go ahead.
Yeah, hi, Rahul. Actually, there are two questions. I'll go quickly. So, first thing, is there any litigation filed is in process for the June 22nd executive order? Is there anything in process?
Yes. There is a litigation filed by our colleague Jonathan Wasson. He used to be with us. Jonathan Wasson filed the litigation for 146 people, if I'm not mistaken. But we're also contemplating to file more. If somebody falls into the category of the visa status, you can contact our office and we'll be able to file the litigation.
Okay, thank you. I have another question is, me and my fiancé are in here in US on H-1B. I have I-140 approved, but she does not have. So if we plan to go to travel outside of country and get married there and I convert to H4 and appear in the visa consulate on H4 and come back here and convert H4 to H1B back. So is that possible right now?
She doesn't have the passport stamping right now and she's going to go also out right now?
No, she has a stamping. She has a valid stamping. But when she was there, can I apply to H4 in consulate?
So the new executive order modifications that were done last week allows people to apply for the H4 when the H1B person is in United States. So I don't know how to take the reading. Do they allow it when you are out, when your wife is outside the country with the H1B stamping? Would they allow it? We don't know at this point of time. But I can for sure say that if your wife is back into United States, you are now allowed to apply for the H4 status there and then get the stamping, and this executive order, they modified it because your wife is here. But why do all this stress? Why can't you just get married and convert into H4 here? I mean, why go all that stress? I don't understand.
Okay.
It's easy. Go to the registration office, go to Las Vegas, spend $200, get the marriage certificate. Boom, that's it. You're out. Why go all the way there and then you risk yourself of getting the stamping there? I don't understand. I like to minimize the amount of involvement of immigration lawyers. They may be nice looking people, but it's better that you avoid them as much as you can. That's a better way to deal with. And when I was a client, I like to deal very less with immigration lawyers. I had a very good immigration lawyer, very proud of him. But at the same time, I don't want to risk myself out and unnecessarily give him more business. Not good idea.
Yeah. Okay, Rahul. Thank you.
Hopefully that took care of that problem. I think,
Sure.
Especially with the given situation and everything, I think what you advised was like the best case scenario for them.
Sure.
Yeah. So Rahul Garu, we have a couple of questions from our YouTube viewers as well. So the first question is from Vivek Nalla. He says he's on a pending B2 and he's asking if he travels outside the US, will the B2 be automatically withdrawn?
If the B2 extension has been filed, if he travels outside, it may not be withdrawn since it's an extension though. If it's a transfer, it will be automatically denied. If it's an extension, they may issue an RFE, they may issue an approval. If the RFE comes in, you can withdraw it, but they have maintained the legal status because the denial occurred after they left the country. So they have maintained the legal status. And even if it's a change of status also, though, when they leave the country, the B2 will be automatically denied. But it's not going to be a bad thing for him. He maintained the status until he left the country. So he's in a good shape if he left the country and they denied because he left the country, if it has been a change of status.
Got it. Okay, perfect. All right. Our next question is from Reshma Pawaskar. So her question is on the S386. She wonders what congressman can she contact to get it passed?
It should be better that you contact the senator instead of congressman though. This bill, Senate 386 bill, is actually passed in the House. It's called 1044 bill. It's already passed there. It's in the Senate right now. So senators is very important. I want you to call, your state has 2 senators. I want you to contact them. I don't want you to just call them. I don't want you to cut and paste the emails that people like us give it to you. You can make use of our content. You can go to immigrationgirl.com. That's managed my business partner, and you can get the content of it. But I want you to write a detailed letter. How long you have been in this country? What is the job that you do? Where does your kids go to school? What does your husband do? What are the social activities that you have involved in? And why is this Senate 386 bill is very important? If that is given, what are the advantages that you are going to get it? And what are the advantages your family is going to get it? I want you to clarify it very clearly I don't want you to just cut and paste it, take it from Immigration Girl and then just copy and paste it. I want you to write a detailed letter so that the senators will understand very detailed things. Now, please, Reshma, when you contact the senator, don't tell that this bill is benefiting Indians. This bill is not designed to benefit Indians. This bill is only taking any discrimination off. That's all this bill is. Don't say that this is benefiting Indians. No, it is just taking the discrimination off, treating everybody equally. So that's another talking point when you contact the senators. I also recommend that, you should, look into it. Say thanks to the congressman that you have if he has voted in favor of the 1044 bill. If you look into it, thank for him. I mean, it's always thank you. You have done a very great job. I hope the senators do the same job. Thank you, Reshma.
Yeah, Rahul, I think you make a very great point, that we don't take out enough time to thank our senators and congressmen, for the work that they are doing on our behalf as well. So I think you bring up a very important point. So for our viewers who are watching, please take out some time in your day and thank the people who are helping us out. And that will also, be a force of change, hopefully, in the whole immigration world. I think today we're all out of time right now. Thank you so much, Rahul Garu. Awesome as always. You're so detailed with your answers, and I hope everybody went away with more clarity than they came with today. Thank you so much for being on the show with us today.
Thank you, Nitya, for inviting me for the show. Thank you.
TVASIA Telugu ప్రేక్షకులందరికీ thank you for watching, and please like, share, subscribe. We are on YouTube, we are on Facebook, we're everywhere. So follow us, stay on this program. We're back every Sunday from 4 to 5 Eastern. So catch us back here, come back with your questions, come back with any issues you have, and we're here to help you as much as we can. So you guys have a great weekend, and we'll see you next week. Thank you, Rahul Garu. All right.
Thank you very much.